fair, Mike, before we got started here, that one of the things, certainly, if we're the prosecutors in this courtroom, we are going to be all over is, regardless of what his parents did to him, as horrible as it was, how do you legally justify putting 2 bullets into the head of his 13-year-old sister?
This is the reason why I don't see this as all that big a deal from the prosecution's standpoint. There is no hiding that the defense theory, and probably what most people think, is that Cody Posey was a seriously abused child. And I don't mean to say that he was not. I certainly don't. In fact, I believe, as I think most people believe by this point, that he was abused. And the tactic of trying to paint him as an exaggerator probably isn't a good one. However, none of this has anything to do with the central prosecution issue in the case, and that is whether or not this defendant was justified or excused for one legal reason or another in all 3 killings, not just the killing of the father, but the killing of the mother and the killing, the stepmother and the killing of the stepsister.
Michael Farkas, I want to just ask you this question. Why is the prosecutor wasting my time, wasting everyone's time? Why not just say, you know what, yeah, these parents were horrible, no further questions, no cross-examination, and just wait to get to the jury to say, folks, you have a duty. The law is the law, and this ain't Iraq, and we can't take guns out on the street and blow off anybody who hurts us. Period. End of story.
Well, I have to agree with you on one point. I don't see any reason for any intense cross-examination of these witnesses. There's really not much the prosecution can do to minimize this while it's happening. You can't stipulate. You can't say, we'll stipulate that the kid's abused, and you can't say, we'll stipulate to what this witness has to say. If I was the defense attorney, I would never stipulate. So the prosecution is a bit hamstrung, and this witness is just another excellent example of how the defense is doing a very good job both supporting their position and refuting the prosecutor's intimation that perhaps the abuse allegations are exaggerated. But another thing you said that is absolutely true and very poignant here is, how does it answer the question of whether or not the law of self-defense has been satisfied, or, well, the only other defense that could have been brought is mental disease or defect, which isn't being brought because we all know that's not satisfied either. How is this going to affect the judge's ruling on the charge to the jury? It may very well be precluded, except with regard to the father, perhaps. And now we're talking about the possibility of jury nullification. So I'm with you.